and it might actually be advantageous for the insured client to settle earlier, although they might not see it clearly at the time, to settle earlier and not, do a motion to dismiss, do a potential appeal, especially if it's a pro se plaintiff, you might get some really frivolous motions in the interim. Just a lot of work to get that eventual dismissal when it might have been even more cost effective for the client in terms of premiums to resolve it early.
I feel like that's such a good point. I kind of want to say it again, but in a different way, just so that people understand it. The way you said it is great, but it's so important that I think to this presentation that people understand it. So a lot of times, especially if you're representing professionals, they may be very resistant to the idea of settlement. They'll say that they'll see it as kind of defeat, I guess, and they're not entirely unreasonable in that belief. So often, but I guess sometimes we will have clients who are, also perhaps not being objective. That they're not assessing this case as they would other cases that they handle themselves, for example. It's very difficult, when they're in the hot seat to be totally objective. So if a settlement opportunity is presented that seems very reasonable, there'll be no admission of liability, confidentiality, it's a small amount. The amount is less than it's going to cost you to even do basic defense work, something that just makes sense. Again, I think firstly defense counsel has to say that. If that's their judgment, they have to say that. I believe this is a good opportunity to settle.